Hello friends, Happy New Year. Today is 1st January 2023 and friends, I want to tell you something, a secret as to how I started practicing and giving advice on USA immigration laws. In the year 1979, a delegation of 40 lawyers had visited Soviet Russia, East European countries, England and Italy, and I was one of the delegates. Next year I thought that I have seen Russia, I have seen England, I have seen Europe. Why do I not see America? So I thought of traveling to America, and then I thought that if I am visiting America, let me visit their courts, let me visit the offices of the attorneys there and learn about their legal system. So I wrote letters to a couple of attorneys there and they all said, yes, you are most welcome, we will take you to the court, we will show you our office and other thing. But one attorney, he thought that I am seeking a job in his office. So he replied by saying, sorry, no position available. I went for my B1, B2 visa interview and the officer asked me, why you want to visit America? I said, sir, last year I had been to Russia, England and other countries and I want to see your country now and I want to meet some attorneys there. He asked me, what is the proof? So I gave him the whole file containing that correspondence. The officer opened the file and the first letter was, sorry, no position available. He closed the file, threw it on my face and said, your application is denied. I was wonderstruck. I could not understand why my application was denied. He just asked me one question, I gave him the file and he just denied my visa. I then started learning about USA immigration laws. And then I realized that when you apply for a visitor's visa, when you apply for B1, B2 visa, the officer, as per the provisions of section 214B of the Immigration and Nationality Act 1952 of USA, has to presume that the applicant desires to stay permanently in America and therefore the visa applicant has to satisfy the officer that he is in reality a tourist only. He doesn't want to stay in America permanently. He has sufficient funds to meet with all the expenses of to and fro ticket, lodging, boarding, etc. And his family and financial ties in his home country are so strong that those ties will bring him back once his time to stay in America is expired. I was not knowing this. I learned this after my visa was denied. And then I thought that if an advocate is unaware about all these things, what about the common people? And then I started writing articles, answering readers' questions on US immigration laws in Economic Times. I wrote in that paper for almost 12 years. Then I also started writing in Gujarati newspapers like Vyapar, Janmabhoomi, Mumbai Samachar, so on and so forth. And till today, I am writing about USA immigration laws in several newspapers and magazines. I have written and published more than 30 books on USA immigration laws. I have conducted about 500 to 700 seminars on these subjects. I have held road shows. I have also given talk on the World Trade Center. But I would like to today tell you about US immigration, entire thing right from the beginning. It was 14th and 15th century and a golden period of India. People wanted to travel to India. Indian silk, Indian mari masala, they were all in demand, great demand in Europe. And Christopher Columbus thought that let me travel. At that time, the idea that the world is round was propagated. So Christopher Columbus thought that if I will travel from west, I will reach to the east. And he set sail with 3 ships to search a new route to come to India. and accidentally he landed on American soil. He thought that he has reached India. He has found a new short route to reach India. And he gave the names of the people residing in America as Red Indians. Columbus, till he died, was under the impression that he has discovered a new route to reach to India. He was not knowing that he has discovered a new country, a new land. Friends, Americans should thank us, no? Because if Columbus would not have started to find a new route to come to India, he would not have searched the America. Okay, anyhow, in those days, in 1492, when Columbus discovered America, there was anarchy in Europe and England. There was plague in England. There was a potato famine in England. Europe also was in the same situation. Kings and the priests, they were fighting amongst each other. They were also oppressing the people terribly. So as soon as people learned that a new land is found, which is vast, and there are lots of opportunity of farming, and it is full of minerals, they started coming to America. Slowly and gradually, people who migrated to America, their number increased. Then those who came there, they thought that if everyone is allowed to come to America, then they will share our riches. So they first said that anyone who wants to come to America must have $15 in their pocket. So they instructed the captains of the ship coming to America that you must inspect every passenger who is boarding your ship, that they have $15 in their pocket. Then they imposed head tax. You are coming to America, you will have to pay 50 cents. This went on increasing, and today also, you know, if you want to go to America, you have to pay visa processing fees. Then they said, we will not allow people who are unwanted, who are criminals, prostitutes, insane, broke, beggars. So one by one, they created grounds of inadmissibility. And today also, there are more than 100 such grounds. If you have them, then you are not allowed to enter America on any type of visa. Then, in California, gold was discovered, and Chinese people rushed to work in the gold mines or to own the gold mines. So Americans created the Chinese Exclusion Act and prevented Chinese from entering America. Japanese workers started migrating to America to work there very cheaply. Japanese labor was very cheap. So America entered into an agreement with Japanese government, a gentleman's agreement, which prohibited or which made Japanese government not to give passports to their citizens who wanted to go to America to work there. So like this, one by one, laws were enacted to prevent people from entering America. Friends, you know, the natural law of migration is push and pull. The country which, like those days, has difficulties, suffering from famine, or there is no food available, or there is no job available, they would push their citizens out, and the countries which offered opportunities would attract, would pull people. So this is the common law of migration, push and pull. But America, they prevented people by coming to their country by enacting laws. And I, after conducting research on this subject for 6 years and more, I have written a thesis on this, and Mumbai University granted me doctorate degree because I propounded a new theory of migration which I have named as theory of legislative restraint. So friends, one by one laws were enacted to prevent people from entering America. America only allowed those people whom it needed. Ultimately, in the year 1952, Immigration and Nationality Act was enacted, which included all different immigration laws, and from that day till today, with its additions and alterations and modifications, that the Immigration and Nationality Act of 1952 still controls immigration to America. Now friends, under this Immigration and Nationality Act, there are two types of visas. Those who want to enter America, stay there for some time for temporary purposes, they require non-immigrant visa. For them, non-immigrant visas are created. And those who want to stay in America permanently, for them, immigrant visas are created. Now, what is this visa? A visa is nothing else but a stamp placed on your passport, by showing which you can request entry into America. Merely because you have visa, it does not guarantee you an entry into America, because you may have obtained visa by misrepresentation, by committing fraud, or the circumstances, the time may have changed. You have applied for visa today and you are traveling after 6 months, a year or two, and at that time your circumstances are changed. So, even if you have a visa, the officer at the border, at the American border, if he finds that you do not deserve this visa, or you have not obtained this visa genuinely, he may refuse you entry also. And mind well, visa are only granted out of America. They cannot be issued inside America. So, the Immigration and Nationality Act 1952 of America created two types of visa: non-immigrant for those who want to enter America for short duration, for some particular purpose, and immigrant for those who wanted to enter America to stay there permanently. Now, each visa has a status. Now, what is the status? If you have a non-immigrant visa, then your status is non-immigrant. That means you do not want to migrate, you do not want to stay in America permanently. And if you have an immigrant visa, your status is immigrant. So, you are entering America to stay there permanently. Now, this non-immigrant visa also have different categories. They are described in this act, and they are given different signs. If you are entering America and you are entering America for a business purpose or as a visitor, then you are granted B1 and B2 visa. B1 visa is for business people, B2 visa is for visitors. If you enter America with B1 visa, then your status is that of a businessman, and you are allowed to do all work which a businessman does. If you are entering America on a B2 visa, or your status is that of a tourist, and you are allowed to do all that which a tourist normally does in America. Now, like this, there are different. B1, B2 is for businessmen and visitors. F1, M1 and J1 is for students. H1B is for people who want to go there and work there temporarily for 6 years. Intra-company transferee, manager, executive and person with specialized knowledge, for them L1A and L1B visa is created, on which you can stay for 7 years or 5 years. Then if you are an artist and you are going there to perform, A P3 visa are meant for you. If you are a newspaper reporter, I visa is created for you. If you are a religious priest, R1 visa is created for you. Like this, for different purpose, for which purpose you want to enter America, different type of non-immigrant visas are created. And for each type of visa, each type of non-immigrant visa, there are certain requirements, certain qualifications. So when you apply for a student visa, you have to show to the consular officer that number one, you know English language, and to show that you have to give test, either TOEFL or IELTS. Then university should give you admission and issue you I-20 form. You have to pay the service fees. Then you have to satisfy the officer in the interview that you are a genuine student, you know English, you have scored good marks in TOEFL or IELTS exam, you have paid the service fees, a US university has granted you admission and issued you I-20 form, and you have sufficient funds to pay the tuition fees, meet with your lodging, boarding and other miscellaneous expenses. You do not have any intention to permanently stay in America or to work there illegally, and your family and financial ties in your home country are so strong that they will bring you back once your study is over. Like that, if you are applying for H-1B visa, which is meant for employees, if American employer needs somebody who is a graduate or has an experience of that of a graduate person, he can file petition after informing the Labor Department that he wants to call for such and such person for such and such work which can be done only by a graduate. And then he files a petition in America which is known as H-1B petition. Once that petition is approved, then the person for whose benefit the petition is filed has to apply for H-1B visa by showing his qualifications in his home country, and once he gets the H-1B visa, he can travel to America and work there for 6 years. H-1B visa now are restricted by quota numbers. 65,000 for those who are merely graduate, and additional 20,000 for those who have done master's course in America. So in all there are 85,000 visa per year which is issued to foreigners, foreign graduates to come and work in America. If you are traveling there as an intra-company transferring manager, if an Indian company is doing well in India and he establishes its branch or wholly owned subsidiary in America, then that American wholly owned subsidiary or branch can invite a person working in that Indian company as a manager, executive or person with specialized knowledge for minimum 1 year during last 3 years. That person who goes there as a manager or executive can stay in America for 7 years, and those who go there as a person with specialized knowledge can stay in America for 5 years, and they can work there in their American company. They can also invite their spouse and children below the age of 21 years to stay with them. For them, first L1 petition is to be filed in America, and after the petition is approved, they have to apply for visa, satisfy the officer here, and then travel to America. If you are an actor, if you are a singer, if you are a musician, P3 visa is meant for you. For this also a petition has to be filed by some American invitee, and once that petition is processed and approved, you have to apply for visa here, show that you are really an artist, you are really a musician, you are really a dancer, and you want to go to America to perform in America. Then if you are a religious priest, if you are working in a religious institution, and if an American religious institution desires to call you, they can sponsor you for R1 visa. If you are a newspaper correspondent, and if you want to go there to cover the news there, you can apply for I visa. Like that, there are different types of non-immigrant visa for which each visa has a different qualification, different requirements. Some are restricted by quota numbers. For some, petition have to be filed in America, and once that is approved, you can apply for the visa here in your own country. They can also invite their spouse or children, unmarried, below the age of 21 years, to stay with them as their dependent. So, non-immigrant visa basically are meant for those who have no intention of permanently staying in America. Now, if you want to stay permanently in America, then what? If you marry a USA citizen, that USA citizen can sponsor you under immediate relative category for an immigrant visa. These are not restricted by any yearly quota, and once you get that, you can travel to America and stay there permanently. Immigrant visa petitions can be filed by American spouse or by children who are American citizens for their parents. Petition has to be filed in America. It is processed and approved within 8-12 months, and then the person for whose benefit the the petition is filed has to apply, show that he is the legally wedded wife or husband of the American citizen, or they are really the father and mother of the American citizen, and then they will be granted immigrant visa. By taking that, once they enter America, they will be granted a green card. Green card's official name is Alien Registration Receipt. Then there are 4 different family preference categories. In a year, $226,000 immigrant visas are granted under 4 different family preference categories. The first family preference category is for spouse and children and unmarried sons and daughters. The first immigrant visa, first family preference immigrant visa are meant for unmarried sons and daughters of USA citizens. Second family preference category are divided into 2. Second family preference A category, it is meant for spouse of green card holder or minor unmarried children of that spouse. Second B family preference category are meant for adult above 21 years age but unmarried children of that green card holder. Then the third family preference category is for married sons and daughters of USA citizen. And the fourth family preference category is meant for brothers and sisters of USA citizen. In a year, under these 4 different family preference category, totally 226,000 immigrant visa are issued, and they are divided equally amongst all the countries of the world. So India gets 7% out of this 2,26,000 yearly immigrant visa. And that is why it takes a long time to receive visa, immigrant visa under family preference category. Under the first family preference category, which is meant for unmarried sons and daughters of US citizens, 23,400 visas are granted every year. In India, Indians get out of this only 7%. Under the family second preference category, which is meant for spouse of green card holders or minor children or major children but unmarried of green card holders, total 1,14,200 immigrant visas are issued every year. And this also is divided amongst the whole world, and India gets 7%. Under the family third preference category, which is meant for married sons and daughters of USA citizens, 23,400 immigrant visas are given every year, and this also is divided amongst the whole world, and India gets only 7% out of this 23,400 visas. For the fourth family preference category, which is meant for brothers and sisters of USA citizens, 65,000 yearly quotas are there. 65,000 immigrant visas are issued in a year, and this also is divided amongst the whole world, and Indians receive 7%. Friends, that is the reason why we have to wait, Indians have to wait for years together to receive immigrant visa under different family preference categories. Then, under the employment-based preference category, there are 4 different categories, and totally 1,40,000 immigrant visa are issued under these 4 different categories, and they are also distributed amongst the whole world equally. So 7% comes to the share of India. To resolve this difficulty, in the year 1990, US government introduced a family-based 5th preference category, under which if you invest $8 lakh in a new commercial enterprise which is conducting business in targeted employment area or remote area, then that investor and along with that investor is granted a green card. If you invest $10,50,000 in a commercial enterprise which is conducting business in a big city, then also you get a green card. So under employment-based 5th preference category, which is created in the year 1990, you yourself invest in a new commercial enterprise, either 10,50,000 in cities or 8 lakhs in targeted employment area or remote area in a new commercial enterprise, and carry on business by yourself and employ 10 Americans in that new commercial enterprise. Then you are granted a green card, immigrant visa. In the year 1992, another employment-based 5th preference pilot category was elected, in which in the recognized regional centers, companies recognized by the immigration authorities in America, if you invest in them, they are known as recognized regional center. If they are carrying on business in big cities, then you have to invest $10 lakh, 50,000. If they are carrying on business in targeted employment area or remote area, then $8 lakh. Then you are granted a green card. You don't have to carry that business. You don't have to take part in the business. You don't have to employ 10 people. It is the responsibility of the regional center to do the business and to employ 10 Americans in that business per investor. But they are granted the facility of creating indirect or induced employment. Meaning thereby that supposing if a regional center employs me as their attorney, I have 25 people working in my office. It would amount to creating 25 jobs. So you can get immigrant visa under 4 different employment-based preference category, or by investing either 10 lakh 50,000 or 8 lakh in a new commercial enterprise or in a regional center. Then America offers 55,000 green card by lottery every year. All that you have to do is fill up the form, write your name, address, birth date, country of residence, and where you were born, and submit it. And if in the lottery your name is selected, you get a green card. But the country from where large number of people have traveled on green card, on immigrant visa to USA previously, their citizens are not allowed to participate in this visa lottery. So we Indians who are availing in large number immigrant visa, green card every year, we cannot participate in the visa lottery. But if you are born in a country which is eligible to participate in visa lottery, or if you are married to someone born in a country which is eligible to participate in green card lottery, then on the basis of your birthplace or marriage, you can participate in green card lottery. So, immigrant visa through which you can enter America, get a green card and stay there permanently can be obtained under first under immediate relative category, then under 4 different family preference category, then under 4 different employment based preference category, then under employment based 5th preference category by making investment, then if eligible by participating in visa lottery. Some also obtain green card by seeking political asylum or refugee status in America if in their country the situation is such that they cannot stay there, they are being harassed, there is famine, then they can seek refuge in America under political asylum or refugee status. And if that is granted, then they can stay in America permanently. If you join USA military, then also you can get a immigrant visa and stay there permanently. Many times America declares amnesty. Amnesty to a particular class of people, amnesty to a particular country. If that is so, you are lucky or unlucky to be in such country. You can get an immigrant visa and a green card and stay in America permanently. Like this, in different ways, immediate relative category, family preference category, employment based preference category, visa lottery, political asylum, refugee status, military, joining military by receiving the benefit of amnesty. All this way you can get a right to reside permanently in America. And if you have received a green card, that is the alien registration receipt, and 5 years has elapsed, or if you have received a green card by getting married to US citizen and 3 years have elapsed, then after that 5 year or after that 3 year, you can apply for becoming a US citizen by naturalization. However, for that you will have to show that during that 5 year or during that 3 year, you have minimum stayed for half the time in America and have never stayed continuously out of America for a period of 6 months or more. You will also be required to give exam of general knowledge of America and English language test. So friends, you can receive permanent residency, you can receive green card, you can receive US citizenship in these different ways. Now what if you have done something wrong? What if that ground of inadmissibility is applicable to you? In some cases, the American government will pardon you. There is a provision of seeking waiver. Waivers are of two kinds, non-immigrant and immigrant. If you want to enter America for short duration under any type of non-immigrant visa, and there is a prohibition because you have done something wrong in the past and you are not allowed to enter America, you can apply for waiver, and if it is granted, you will be allowed to enter America on that non-immigrant visa. If you want to migrate to America, if you want to immigrate to America, but you have done something wrong and there is a ground of inadmissibility against you, then you can apply for a immigrant waiver, show the hardship and other requirements and get a immigrant visa, immigrant waiver, and enter into America and stay there permanently. Now supposing someone has filed immigrant visa petition for your benefit under family preference category or immediate relative category, and that person after the petition is approved expires, then what? The petition comes to an end. In these circumstances, if an immigrant visa petition which is filed and which is approved, but under which visa is yet not available, person is waiting in the queue to receive the visa, and the petitioner who has filed the petition dies, expires, then there is a provision of substitution. There are certain other, if other relatives defined in the Immigration Act are there, then those people can apply and request that they may be substituted in place of the deceased petitioner in that petition which is already approved, and they can show that they are ready and willing to file affidavit of support for the beneficiary of that petition. Then if they are substituted, then the beneficiary for whose benefit the petition is filed can receive immigrant visa under that petition whose original petitioner has expired. Under this family preference category, children and spouse, children of the beneficiary, supposing your US citizen brother sister has filed petition for you, along with you, your minor children below the age of 21 years who are unmarried can also receive dependent immigrant visa. But by the time the petition is approved and becomes current and you are eligible to apply and receive immigrant visa, your child has crossed the age of 21 years. Then what? In such circumstances, the US government has specially enacted Child Status Protection Act. Under this act, the time, the day when the petition is filed, the priority date, and the day when the petition is approved, that much time is allowed to be deducted from that dependent child's age. So supposing a petition is filed today and it is approved after 1 year, and before it becomes current, before the beneficiary can receive immigrant visa under that petition, the child who is also a dependent beneficiary crosses the age of 21 years. Then the beneficiary can apply for protection under Child Status Protection Act, asks for deduction of that 1 year, and if by deducting that 1 year the child's age is below 21, that dependent child can receive the dependent immigrant visa. Like this, there are so many benefits, so many things are available under the Immigration and Nationality Act 1952 of America. Non-immigrant visa, immigrant visa, different types of categories under which you can receive immigrant visa, provision for Child Status Protection Act, provision for substitution, provision for waiver. If you have travelled on a non-immigrant visa and then you marry somebody there and you want to change your status and become immigrant, then there is a provision of change of status. If you have gone there as a tourist and then you want to study there and the college gives you admission immediately and you don't want to travel back to your country and get the student visa, then there is a provision of change of status. So there is a provision of adjustment of status from non-immigrant to immigrant. There is a provision for change of status from a category to different category of non-immigrant visa. Like that, there are so many other things which is available under the Immigration and Nationality Act of America. So friends, today I have told you in brief, in nutshell, the entire USA immigration laws. Yet, if you do not understand anything, you want some more clarification, you have some specific questions, don't worry. Don't take tension. मैं हूँ ना? And my mobile number is 98204-19469 and my email is Sudhir Shah 1940 @gmail.com. SUDHIRSHAH1940 @gmail.com. So friends, I wish you once again a happy 2023. In this year, if you want to travel to USA on a non-immigrant for temporary purposes or to stay there permanently by receiving immigrant visa, I have told you in the everything about USA immigration laws. Still, if you have any questions, if you want to know anything more in detail, don't take tension. मैं हूँ ना?